For the record, will you please state your name and spell your last name?
Christopher Long, L-O-N-G.
And Dr. Long, how are you employed?
I work for St. Louis University School of Medicine, Department of Pathology. I direct the Forensic Toxicology Laboratory for them. We do most of the testing for the city and county of St. Louis, the surrounding counties. We do work for as far away as the Upper Peninsula of Michigan to Virginia, to New Orleans, to Boulder, Colorado.
Well, do you know a person by the name of Dr. Michael Chambliss?
Yes, sir.
And you've consulted with him before too, correct?
Yes, sir. We still consult.
And he's in Fresno, California.
That is correct.
So you go further west than Colorado.
Yeah, he calls me up about different cases and to interpret them.
So, Dr. Long, can you tell the jury what sort of training, experience, and education you have which qualifies you for this occupation?
Sure. Well, I have a bachelor's degree in chemistry from Marist College, which is in New York. I have a master's degree in medical biology from Long Island University, also in New York. I have a second master's in pharmacology toxicology from St. John's University in New York. And my doctorate is in toxicology, and that's from St. John's. I've also excuse me, I've also been working in the field something over 30 years, and I am board certified in forensic toxicology and have been so since, approximately 1988 is when I got certified. And you have to requalify every 5 years. And I teach medical students, residents, interns, and the lay population about drugs and alcohol and the effect on the human body.
And what exactly does a forensic toxicologist do?
Well, forensic toxicology. Toxicology is the study of harmful effects of drugs and chemicals on living systems. Forensic toxicology studies these in a way that the data may be admitted into a court of law.
And Doctor, were you ever called upon to examine any of the evidence that was collected in the case of the state of Wisconsin versus Mark Jensen?
Yes, sir.
And tell us how that came about.
Well, excuse me. We do work for various counties up here in Wisconsin. And we were contacted by a pathologist for a retest on a sample and to look for specifically ethylene glycol. We received the samples and we tested them.
When the samples that you received, were they sealed in any way?
Yes, they were sealed and undamaged. I don't recall specifically how they were sealed, but it's sealed and undamaged, and that's noted on our chain of custody.
And
Can I have some clarification if that's personal knowledge?
well, Your Honor, doesn't he get to do that during his cross-examination?
Well, it may be something that ought to be addressed before he gives his direct testimony.
Well, I'll go through this in
All right, go ahead.
more detail then, Your Honor. So tell me, Dr. Long, did you personally examine yourself these items under microscope or under gas chromatograph, or were they done by members of your lab?
I did not touch the samples. It was done by members of the laboratory.
And tell me what the procedures are that your laboratory employs when you receive samples in a criminal case.
Well, potentially all of our cases are criminal. That's why we're a forensic laboratory. Otherwise, it'd go to a hospital laboratory. When we receive samples, it's documented how it's received and the condition in which it's received on the paperwork, and when and by who it was received. It is then logged into the laboratory. It is assigned an accession number. We don't use names, we use numbers. And the numbers are applied to all the samples and to all the paperwork. So that's how we trace it. The samples are then tested by the various individuals, where they would take an aliquot or a portion of the sample and run that through various tests. They would then put it into the case file. I would review the file and sign off on the report.
Now, when you review the file, you examine to ensure the chain of custody has been followed?
Yes, and that the data is consistent.
And Did you do that in this case?
Yes, sir.
And do you remember, as you're sitting here, without looking at any of your documents or any of your records, what specific samples were examined?
Well, I know we tested blood, urine, gastric, liver, and brain.
And was there a report prepared as a result of that?
Yes, sir.
I show you this item as marked as States Exhibit 9, and I ask you if you can identify this document.
Yes, this is a copy of our toxicology report, and it has my signature on the bottom here.
And
I'd ask, I don't really have a problem at this stage, but the witness took it upon himself to show the jury, which is improper until an exhibit is admitted. I don't know if this one has been.
Well,
Again, I just don't want it happening in the future more than I'm concerned about this particular instance.
all right, you should try not to do that, Doctor.
Okay, Your Honor.
so, Dr. Long, tell the jury what Exhibit S9 is, please.
Well, this is a copy of our toxicology report. It is on a Julie Jensen, and it is toxicology number 99-1177. And it was received from the Kenosha County coroner, and gives us a quick summary of the history, and then it summarizes our test results that we reported out. And my signature is at the bottom, along with the date it was typed up.
And what was the date that was typed up?
May 14th, 1999, at approximately 4:07 p.m.
And doctor, how much ethylene glycol was found in the blood of Julie Jensen?
Objection, confrontation.
We're going to take an early lunch today, and I'm going to ask that you return at 12:45. Can you do that? Please don't talk about the case during the break.
Please, all rise.
Mr. Albee?
Judge, Dr. Long has indicated that he's not the one who prepared the test results. That was done by somebody else in his lab. He's also already indicated that every case they receive, and certainly this one, it would have been known, is potentially criminal. These were prepared as statements for use in a criminal trial, and therefore they're subject to the right to confrontation, and those individuals who did the testing are not here. Dr. Long's trying to report their hearsay statements, and I have the right to cross-examine the people who did the actual testing.
Mr. Jefferson?
I guess he could call him if he wanted to, Your Honor, but I don't believe that's required in order to introduce this into evidence subject to cross-examination of this witness. And there is case law in the state of Wisconsin where people who are the lab directors or the persons that are responsible for the lab can testify as to the results of studies and reports that were prepared in that lab. And that's the theory under which we're seeking to have Dr. Long testify. It's my understanding that Dr. Long personally examined the gas chromatograph results, and that he examined all of that before he signed off on this report. And I believe that he can testify based on that. I don't believe we have to have, I think the person who actually did the report was Deborah McGill, is that?
There were two people, Diane McGinn and Joseph Kerfassi.
Okay. I don't believe we're required to produce them and have them testify as to what they specifically did in terms of mechanically preparing these items and then placing them in a gas chromatograph machine. I believe that
How would the defendant be able to cross-examine them to make sure it was done properly?
he can cross-examine Dr. Long, Your Honor, and there is case law in the state of Wisconsin we're looking for right now, which indicates that a person who is responsible for the laboratory can testify as to the results of tests performed in the laboratory by persons under his employ and supervision.
In a post-Crawford criminal trial where the report is a testimonial statement that was prepared for purposes of a criminal prosecution?
Well, Your Honor, all I can say is that there's case law in the state of Wisconsin. I would have to look at it to see if it's post-Crawford. I sincerely doubt that it's post-Crawford. But even under Crawford, Your Honor, records are admissible. Business records, for example, are admissible. And
The business records, I don't think a business record is admissible if it's prepared for purposes of a criminal litigation. Specifically prepared for criminal litigation.
Yes. Well, Your Honor, we can arrange for those witnesses to be here, I suspect. Are they still employed by your lab? We did not arrange for them to be here. We arranged for Dr. Long to be here to testify as to these results. Now, if the court is going to require that we produce those witnesses, we can produce them, and I'd request that this witness be permitted to testify, and we'll tie his testimony up later on by producing these witnesses, I imagine early sometime next week. But I will say this, I don't believe that it's required. And I guess that before I produce those witnesses, I would want an opportunity to explore the relevant case law, because I don't think that is required in a pre or post-Crawford world. I believe that Dr. Long is qualified to testify concerning these results that were established in his laboratory.
Did you want to respond, Mr. Albee?
I think that these statements of the people who performed the tests are clearly testimonial. They are made in anticipation of use in a criminal case, and that they are therefore covered by Crawford. I would also alert the court and counsel to a second issue that will arise momentarily, and that is there is no chain of custody as to the gastric contents whatsoever, and I don't know how they're going to establish it. Dr. Chambliss didn't remember taking the gastric contents, and he also did not put it in his report.
Well, Your Honor, actually, what Dr. Chambliss put in his report is that there were 660 milliliters in the stomach. Now, he did not put in his autopsy report that he actually collected them. But that doesn't mean that there's no record of it. And the fact is that Dr. Long will testify that he's examined, that he has, I believe he has all the records with him. Did you bring them with you today, Doctor? He's got the records with him. He can go through the chain of custody bit by bit, piece by piece, and establish what was there when they did the testing. So if there's a chain of custody objection at some point on these issues, we can address those. I don't believe I'm required to produce the specific technicians who perform the gas chromatographic analysis, but if that's the court's ruling, we will produce them at some point. I would request then that this witness be treated as a witness who's being taken out of order on the understanding that we produce them. And it is my understanding that Dr. Long has indicated both of these employees are still there at the St. Louis Forensic Crime Lab. They're both available in the next week or two if we recall them as witnesses.
I believe so, yes, sir.
So we could get them here.
It would be my inclination to allow the district attorney to call these witnesses at a later point and subject them to cross-examination, and then unless he can present me with authority for the proposition that he needn't do that before he does it. But it's, and also to permit Dr. Long to testify now based upon that assurance. Do you have any problem with that?
I don't. Obviously, it's subject to it being connected up if there's a confrontation issue that the court finds, but I agree that that makes sense to proceed in that fashion. As to the chain of custody, the problem, of course, isn't Dr. Long's records as to chain of custody after it's received in St. Louis. It's chain of custody as to whether gastric contents ever were collected and stored in the first place. All we have is evidence of weighing, and not that they were saved for purposes of analysis.
When you say Dr. Long is going to go through the chain of custody, he's in no better position to recite the chain than I am.
How could you say that?
Because he's not going to be able to testify that what he received is identical to that which was drawn from the decedent. I assume that you have something on the Kenosha end of this to a witness who can testify, perhaps Dr. Levin or someone.
We have...
Dr. Lavin could probably do it.
Dr. Lavin probably could, and the deputy medical examiner could probably do it, or the current medical examiner could probably testify.
Well, I don't want to get into what...
And there's a wide variety of people that we could do that. I will say this, Your Honor. Ordinarily, chain of custody does not go to admissibility. Chain of custody goes to the weight that the jury's going to ascribe to it. But there are witnesses, there are witnesses that are being called somewhat out of order. Dr. Mainland hasn't testified yet, Your Honor, and Dr. Mainland is the current Kenosha County medical examiner.
Look, I'm not going to tell you what to do. I think that chain of custody may be an issue. He's brought it up. He's alerted you to that.
Yes, sir, he
And
has.
I'm telling you, I think the chain of custody, is not as important as it used to be when you're dealing with identifiable things, like pieces of paper that have people's signature on them, and a firearm with a certain serial number on it. But when you have something that is not very individual, like a container containing some human tissue or something that was found inside the human body, you do have some chain of custody issues, some of which can rise to the level of admissibility itself. We'll see. But he's forewarned you, and we don't need to haggle about it now.
I agree with
As
that.
so many other issues, it may evaporate. So I
That is
would,
what I expect it will do, Your Honor. But with respect to this one issue, what I would propose to do over the... Did you release the jury for lunch, Your Honor? Is that what...
I did.
Okay, so what time are they due back?
1:45.
So what I would propose to do over the lunch hour, in addition to eat, is talk to Dr. Long, and we'll confirm the availability of these two other witnesses. Now, what I would ask...
And you can also try to find those cases. If you've got some authority for the proposition that Mr. Albee is in error in his objection, then I'll certainly hear that. But otherwise, yeah, go ahead.
My guess, Your Honor, is that the case law is probably pre-Crawford. That would be my guess. But I'll examine the case law. My other concern is the possibility of having these two witnesses testify via telephone rather than testifying in person, since it would be expensive to drag...
I'll talk with the defense about that.
Okay, well...
And see if there's
you
something-
agree? We also see.
Why don't you talk about that, and what else? Anything else we need to do right
No,
now?
I think that'll pretty well cover it.
All right. We'll see you at 1:45.
Okay, thank you, Your Honor. Would you agree with that?
Good afternoon, everybody. Let's continue with the examination of Dr. Long. We're going to continue the examination, and I'll deal later with the issue that was raised just before the break. Go ahead, Mr. Jambois.
Thank you, Your Honor. Dr. Long, I'm going to show you this item that's been marked as Exhibit F-119. I ask you to look through that and perhaps compare it to these documents here and tell me whether or not you can identify them.
This is a copy of our case file. This is basically the paperwork that was generated in doing this testing.
And there are numbers on the bottom corners of each of these pages, is that correct?
Yes, the last one is 192.
And please direct your attention to, this is the original file? over
Yes.
there. And that's similarly numbered to 192?
Yes.
So I guess I will be asking you to look at your file,
Okay.
and I'm going to refer to Exhibit S-119, provide a copy to the defense counsel, and now I'll provide a copy to the court, Your Honor. Your Honor, that you may follow along.
Thank you.
So, Dr. Long, I don't remember exactly where we left off, so what I want to do is pick up with if you can tell us, and if you need to look at Exhibit 119 to refresh your recollection on any matter, I wouldn't object to you doing that, but please let us know when you're looking at the exhibit as opposed to testifying from your independent recollection. Would you do that, please?
Yes, sir.
Now, do you know as to your own independent recollection on what date it was that you received the items that you tested with respect to this case?
Offhand, no, sir.
Would it assist you to look through Exhibit 119 in order to obtain that information?
Yes, sir.
Well, then please do so.
Yes, the samples were received May 11th, 1999 at approximately 11 a.m.
And what page are you looking at, sir?
That's page 2.
Page 2 is also reflected in Exhibit S9, is that correct?
Yes,
You have S9 there?
yes.
So the document that's been previously marked as S9 is also reflected in page 2 and 3. Is it page 2 and 3?
Yes, page 2 and 3 and 5. Page 2, 3, and 5.
Pages 2, 3, and 5 of Exhibit S119 are also found in Exhibit S9.
Yes.
Now, Doctor, about how many toxicological tests does your toxicology lab perform in the course of a year?
Oh, we run now about between 8,000 and 10,000 a year.
And are there a variety of pieces of equipment that you employ to run toxicological tests?
Yes, we use various instruments. Yes, sir.
Tell what instruments were used to test the items that were submitted for review in this case?
There were two types. One is called a gas chromatograph. Chromatography means separation. Gas chromatography means separation in a gas phase. So this separates out all the compounds. The other one that was used was gas chromatography mass spectroscopy. So you get the separation from the gas chromatography, then you get the mass spectroscopy, which is where the molecule is like my fist. It's hit with very high energy, causing it to explode. That gives you a fingerprint identification. So the ethylene glycol was identified by its molecular structure.
And do these tests establish not only the presence, but do they also establish the relative quantity?
Yes, sir.
And how is that expressed? Is it expressed as a ratio?
It's a weight per unit volume. So it's micrograms, which is a weight, per milliliter, which is a volume.
Now, looking at the blood sample that was obtained from the person of Julie Jensen, when you performed, what test did you perform on the blood of Julie Jensen in order to determine the presence or quantity of ethylene glycol?
Well, both were for the final report. Originally, it was gas chromatography, and that identified ethylene glycol in the blood.
And then what was the next test that was performed?
That was the mass spectroscopy giving us molecular structure.
And how do those tests afford you the opportunity to determine the presence or the quantity of ethylene glycol in the blood?
Well, you run standards, you run an internal standard. When you're running the test, you start out with a sample, and you put something that you know in it at the start, and then at the end, you want to see that come out. That way you know everything in between worked, okay? Because it's injected into these instruments. Excuse me. So originally it was done by gas chromatography. So we get the separation, and then we get standards. So we take our sample, we add our internal standard, which is the front and back check, and then we add known quantities of ethylene glycol, and then we want to see them come out proportionately at the end. That gives us both our quantitation and qualitative. So we've identified it and we've quantitated it. When that was completed, excuse me, we took it on to mass spectroscopy, which again, it was the exact same thing, the internal standard and the ethylene glycol with standards, and then we got a molecular structure and matched it up to knowns. So we knew what ethylene glycol looked like and its mass spectral pattern, and then we quantified it based on that.
And what was the quantity of ethylene glycol in the blood of Julie Jensen?
The ethylene glycol, the original test showed 55 micrograms per milliliter. That was by gas chromatography. When we went back and did it by mass spectroscopy, we got 50 micrograms per milliliter, which is a little less, but mass spectroscopy is a far more accurate procedure. So that's very reasonable, and it's within a standard deviation. We then went on to test, excuse me, the femoral blood. The femoral blood is in a leg vein. Okay, so if the blood's sitting there, it's going to be altered. And in the leg vein, we demonstrated 14 micrograms per milliliter. So we tested the blood 3 different times.
And can you account for the apparent discrepancy here that the femoral blood was 14 micrograms per milliliter, whereas the blood that was obtained elsewhere was higher at 50 or 55 micrograms per milliliter?
Sure. See, ethylene glycol is an alcohol, and alcohols will diffuse quite readily. So all it is you have some alcohol sitting in a vein, there's tissue around it, it diffuses from the vein into the surrounding tissue. It just follows the concentration. So that would be a very reasonable explanation as to what happened.
And then, did you test the urine that was obtained from the person of Julie Jensen?
Yes, sir.
And what was that test result?
By the gas chromatography, it was 720 micrograms per milliliter. By the mass spectroscopy, it was 549 micrograms per milliliter.
And then you tested the gastric contents?
Yes.
And what did the gastric contents reflect?
By gas chromatography, it showed 3,940 micrograms per milliliter, and by GCMS, it shows 4,121 micrograms per milliliter.
And Judge, just to be clear, we have that issue that we'll take up later as to the gastric.
Right.
And then directing your attention to the results of a liver sample, when you tested that, what did you discover?
By gas chromatography, it was negative. By mass spectroscopy, it came in 51 micrograms per gram.
Is that unusual, or can you account for that? Can you account for that discrepancy?
When you're doing tissues, you have to grind up the tissue, which means you're diluting it out. You're making like a 1-to-4 dilution. So in the gas chromatography, which is not as sensitive as the mass spectroscopy, you can miss it. You can get a false negative, which is what happened here. The mass spectroscopy is far more accurate and has a lower limit of detection. So that's why it identified the ethylene glycol, and we were able to report it based on the mass spectroscopy.
And similarly, when you performed a test on the brain tissue of the person Julie Jensen, what did you discover?
But, excuse me, by the original testing, gas chromatography, it was negative, and by the mass spectroscopy, it came in at 16 micrograms per gram.
Now, doctor, how much ethylene glycol would you normally expect to find in the tissue of a human being?
Ethylene glycol should not be present in a human body.
Now, what I would like you to do, doctor, first of all, and as a result of your training and your experience as a forensic toxicologist, are you familiar with the effects that ethylene glycol has on the human body?
Yes, sir.
What I would like you to do is describe to the jury what ethylene glycol does to the human body after ingestion.
Well, excuse me, ethylene glycol is an alcohol. So you get a lot of the same effects as alcohol. That is intoxication, slurred speech, staggered gait. It's like you're drunk, but there's no smell of alcohol on your breath. What happens then, that's when the ethylene glycol concentration goes up, okay? And that can happen between 30 minutes and I guess about 10 or 12 hours. So the concentration goes up and you're drunk, in effect. Then the ethylene glycol is metabolized. What your body does is it takes this chemical and it changes it over into something else. In the case of ethylene glycol, it goes through several steps, but it ends up as oxalic acid. Okay, oxalic acid is very harmful to tissues. So it goes in, it tears up your heart, your lungs, your kidneys, okay? So the ethylene glycol drops down and the oxalate goes up. And as the oxalate goes up, you get more and more toxicity. So you can have low levels of ethylene glycol and still have very significant toxicity. That's because it's the metabolite.
Explain how that could happen, doctor. Explain how you could have a very low level of ethylene glycol in the blood and a very high level of toxicity. If there's more than one way that could happen, please explain each way that it could happen.
Well, the only one way is, well, there are two ways. One is you get repeated small doses. So that is to say you're getting multiple doses and you're getting to more and more toxicity. So at any given time, you have a low concentration in the blood, but the toxicity is building up more and more. That's one way of doing it. The other way of doing it is you have a big dose of ethylene glycol and then it drops down. Okay, your body is eliminating it. Much the same as you have a drink of alcohol, it's eliminated. But when it's eliminated, then the oxalic acid accumulates in the tissues. This is where you become acidotic, okay, where you feel nauseous, you're sick, you get blurred vision. You can have tachycardia, you can have renal failure, you can have blood in your urine. So there's a lot of other things that can happen to you because the oxalic acid is damaging your tissues, and the kidney is one of the target organs. But those would be the two methods that I could think of.
And doctor, can you tell the jury what tachycardia is?
That's when you get a racing heart. Okay, your heart starts beating faster and faster. Instead of just sitting there relaxed and so forth, your heartbeat takes off.
So you've described how many stages so far of the results of ethylene glycol poisoning?
Well, there's basically 3 stages. Stage 1 is like the acute intoxication. This is where you get the drunken-like behavior, staggered gait, and so on. Then in stage 2, the crystals are formed. This starts about 10 to 12 hours post-ingestion, okay, and goes to about 24 hours. This is where they drink a lot more water. They're very thirsty, okay? Excuse me. Got a frog in my throat.
There's some water there, doctor. Would that be of assistance to you?
Yes.
How about a lifesaver? Would that be helpful?
No, thank you, Your Honor.
Oh, okay.
So then in the second stage, you have these crystals. So what happens is they become acidotic. They're feeling sick. They're throwing up. They're nauseous. They have diarrhea. So they have like a really bad case of the flu. They really feel sick. Then in stage 3, that's where you get more toxicity, like the heart, the kidney failure. You get major organ failure, which can result in death. And that usually occurs at about 24 hours.
Can you describe this, doctor? A person who ingests ethylene glycol and then dies as a result of that ingestion, is that a quick and painless death, or is that a slow and painful way to die?
That would be a slow and painful way to die.
Now, doctor, in the course of your experience, have you encountered persons who were poisoned as a result of a homicide?
Yes, sir.
And have you encountered persons who were poisoned as a result of a suicide or a suicidal intentional ingestion?
Yes, sir.
And is there any differences that you've noted in the tendencies in between homicides and suicides in terms of the quantities of the substance that you find in the blood or in the gastric contents or elsewhere in the body?
Objective Foundation and 702, 90702.
Objections overruled.
Yes.
Tell the jury what what differences you've noted between intentional ingestions that were suicidal and ingestions that turned out to be the result of a homicide.
When somebody is suicidal, their intent is to take their own life, which is a very sad thing. However, what we find is, say like they have 10 bottles of pills here. They don't just take one pill, one of the medications. Generally speaking, they take pretty much anything that they have to make sure the job gets done. So you find multiple drugs at very high concentrations. That's generally from a suicide, okay? Can somebody take it from a single pill bottle? Yes, they can. But generally speaking, if the medications are present, they will take multiple meds to ensure the job gets done. In the case of a homicide, usually you find just one compound because they're not able to get multiple drugs into them. They're only able to get one in there, whether it's arsenic or whatever it is. They're only able to get the one compound in them. So that's a general description between the two.
I have a continuing objection and move to strike.
You'll need to object by specific question,
Well,
because otherwise I don't know what.
I thought I did beforehand. I don't believe
I
there's any-
overruled that, and that's specific ground, I suppose, but if there's anything additional that you find objectionable, you'll have to separately state it.
Still lack of foundation in 90702.
All right, that's overruled.
Have you noticed over the years in examining the differences between homicides and suicides, anything concerning the quantity of substance that is ingested?
Yes, sir.
What have you noticed concerning the difference in the quantity of the toxic substance which is ingested as between homicide and suicide?
Well, generally speaking, in a suicide, you find a very high acute dose. You find a lot in the gastric, you find it in the liver, you find a high concentration in the blood, generally speaking. As compared to, say, and we've had chronic poisonings that are homicide, where they get a little bit every day, and so the toxicity keeps accumulating, but the drug concentration or the poison concentration stays low.
Now, doctor, based upon your evaluation of the physical evidence that was submitted to you in this case, do you have an opinion to a reasonable degree of scientific certainty as to the manner of death in this case? Is the physical evidence that you have examined and the findings that you've made more consistent with a homicide or a suicide?
Objection, foundation, and 90702 beyond his expertise.
Overruled.
Yes, I do. In this particular case, you're looking at multiple doses, okay? This individual was sick for about 3 days. Okay, the crystals were already formed, which takes a minimum of 10 to 12 hours. Then there was ethylene glycol detected in the stomach. The night before her death, she was reported as vomiting and diarrhea, which would mean a purging of the system, so there should be nothing in there. But the next morning, she had ethylene glycol in her stomach. So that would go to multiple dosing. Furthermore, there was no ethylene glycol found at the site, and I believe the police even took the traps out of the sinks to see if there was anything that had been washed down the sink, and they could test that. So there was no ethylene glycol present. There's nothing really to support a suicide.
Now, doctor, if you heard a layperson make the following claim, I want you to determine whether or not there's any toxic substance which in your experience would fit this description from a layperson.
I object to relevance.
I'd have to hear the whole question.
Okay, so the question, doctor, is this. If you heard a layperson state that he was intending to kill his wife and that he was going to do so with a substance that would cause her to crystallize from the inside out and would not likely be found at autopsy, is there any toxic substance that you're familiar with in your career that would fit that description?
And I object on relevance grounds.
Overruled.
Yes,
What would that substance be?
ethylene glycol, because its mechanism of toxicity is to be metabolized and to form crystals. So when it's metabolized, the concentration drops, and yet the toxicity increases. So you do not find, or you may not find, the ethylene glycol at an autopsy sample. It is something that wouldn't be looked for unless it was specifically requested. Most toxicology tests do not include ethylene glycol as part of their general screen. So just go through as a negative.
This is well beyond the scope of the question.
The only objection you would have would be relevance, because otherwise that's the questioner's objection, so.
I understand, but
You're overruled.
Okay.
Were you finished, sir?
Yes, sir.
Now, Doctor, there was a previous letter that you'd submitted to the prosecution in this case where you had described the amount of ethylene glycol in Julie Jensen's gastric contents in a particular fashion. Do you remember how you described it?
Yes, I use the word large.
You said it was a large amount?
Yes, sir.
And in retrospect, do you think that's a fair or accurate description of the amount of ethylene glycol that was in her stomach?
Well, the context that's been used is compared to how much actual ethylene glycol was in her stomach. No, it's not accurate, because it comes out about, a teaspoonful, maybe a little bit more than that. So no, that's not considered a large amount. If you had a couple of shots of ethylene glycol in the stomach, then yes, that would be considered a large amount. When I had made the original comment, I was looking at compared to the blood concentration, but I understand how it was taken, and I would not use the word large again.
Now, there was a question. I'm trying to think what it was that I was going to ask next.
You'll think it on the way home.
I'm going to think of it before that. Oh, let's go to the chain of custody that, in this case, where would that be found in Exhibit S-119, the chain of custody documents?
The sample that we would have received goes to page number 6, showing the test request coming in, and page 20.
Now explain, first of all, page 6. Explain what that is.
Page 6, when samples are sent to us, and as I said, we do samples from Wisconsin to New Orleans to Virginia to Boulder, Colorado. Excuse me. So when the samples are sent in, we need some paperwork with it. So it's tracked by the paperwork. So we get a brief history of it, we get the name, some pertinent information. So when we get that, that's the paperwork documenting our receiving the samples. They check off what samples they've received, okay, and they gave us a history on this and who to send the report back to. That's on page number 6.
And then describe what's on page 20, please.
Page 20, when we open it up, because it comes in on an airborne or FedEx, we open the box up and see what's in there. And all the samples have to be labeled with the name and so on, and some identification of the source. So we would check all those against the external chain, and we would mark down on this what we received at that time. Sometimes they check the correct boxes, sometimes they don't, but this is what we actually received at that point. So we list all the materials.
And that's contained on page 20 and page 21?
That's on page 20. Page 21 is the chain of custody documenting the handling of it for accessioning. Accessioning means numbering it. So we use the year, like 1999 would be abbreviated 99 dash some number, and it would be sequential.
And then section C, it refers to the and this is on page 22, refers to the analysis of ethylene glycol and makes reference to blood and urine and gastric and liver and brain.
Yes.
And you reviewed all of this. These actual tests were performed by analysts in your lab, is that correct?
Yes, sir.
And then you reviewed all of this work product before signing off on this test result?
Yes, sir. See, our system is set up in checks and balances so that everybody is responsible for part. That way, the parts all have to agree in the end. Okay, so it's got to make sense in the end. That's where I come in. If it doesn't make sense, like for example, one person gets a positive, the other gets a negative, that's a question. We have to pursue that. And it's a checks and balances.
And now I remember the question that I was going to ask you before when I was drawing a blank. And it relates to the amount of ethylene glycol that, in your estimation, would be minimally necessary in order to accomplish the death or the murder of a woman who weighs between 100 and 110 pounds.
Ethylene glycol is the fatal level, or the minimum fatal level, is considered at 100 milliliters, meaning about 3 shot glasses, or a little bit more than 3 shot glasses of ethylene glycol would produce, generally speaking, a fatality.
Now, would that be enough to kill me?
Quite possibly, yes, sir.
And I'm weigh about almost 200 pounds, it'd be enough to kill me.
Quite possibly, yes, sir.
And then if we were to take a person that's closer perhaps to Julie Jensen's size and weight, we could take Ms. Gabrielle, who weighs, as you can tell, a great deal less than 200 pounds. It would certainly be more than enough to kill her.
Yes, sir. It'd be you have much greater odds. If you have a smaller body mass and you take in a toxin, the odds are it's going to have much more of a detrimental effect to you than if you're a larger person.
Now, what are the implications of taking ethylene glycol a little bit at a time instead of taking it all at once in terms of the amount of time involved between the point of initial ingestion and the point where it's going to flat out kill you?
Well, you can die both ways, okay? Whether you take a massive dose, let it metabolize, and you die, or you can drag it out over a series of doses and still produce the same toxicity. So either way, it can be fatal. It's difficult to say, okay, we have a 140-pound person and 100 milliliters will kill them. And if I give them 5 or 20 doses of 5 milliliters or teaspoons, that'll kill them. The reason we can't say that is because we can't test humans and give them poisons and say, oh, well, we killed 100 people here with this dose, so now we know we can do this. So you can't do that. So most of it is anecdotal, which means you can't say absolutely, positively, unequivocally. Okay, but this is what we've seen before, this is consistent what's been reported, this is out in the literature, and this is what we expect.
Thank you, Doctor. Now, when you're talking about anecdotally and what you've seen in the literature, have you had occasion, because of your occupation, to examine what's in the literature in terms of the range of the amount of ethylene glycol that's been discovered in the blood of a person who ends up dead as a result of ethylene glycol poisoning?
Yes, sir.
And what has the range been reported to be?
The range generally is pretty high. It's higher than the 50 micrograms, or the 55 micrograms per mil. I believe it's about 200 micrograms or greater. Because usually what happens is the person is found closer to the time that they consumed it. So you have the toxicity and they expired. What you can have, well, as I said, about multiple smaller doses, but so while the dose is higher, it doesn't really matter. The fact that it's present, the fact that you have the pathology is really what you look at. When you see the kidney and you see the crystals in the kidney, which are, in my opinion, diagnostic for ethylene glycol because they're oxalate, if you find that then you find ethylene glycol, then you have an ethylene glycol poisoning.
Now, Dr. Long, you've indicated that you have consulted with and worked with Dr. Michael Chambliss in the past,
Yes, I still do.
and you found him to be an able pathologist.
Objection. That's an improper opinion testimony.
Sustained.
Well, Dr. Long, if Dr. Chambliss were to call you up and say, look, I don't think this woman died from ethylene glycol poisoning because her ethylene glycol blood level was only 55 micrograms per deciliter or milliliter, what would you say to that?
I would ask him what pathology he had. I mean, if she had been run over by a train, well, then, you have a whole different story. But I would ask him what pathology he had, what he saw going on at the autopsy, what he identified.
And so, doctor, this is the way that you consult with pathologists on a regular basis?
Yes, sir.
On a daily basis, almost?
Yes, sir. I handle probably between 50 and 80 phone calls a day.
from pathologists and other toxicologists and law enforcement and prosecutors?
And defense lawyers?
I was going to ask you defense lawyers too. Okay. So, well, let's say that I'm going to posit to you a hypothetical factual situation. So I'd ask you to listen carefully to the hypothetical factual situation that I provide to you.
Yes, sir.
Whether it's coming from Dr. Chambliss or somebody else, but a pathologist calls you and says, well,
This calls for improper speculation. This isn't a proper hypothetical opinion. He's not giving a toxicology opinion.
Well, I think he's, I think he's framing an illustrative example of a situation in which a hypothetical opinion would be given, would be asked and given. And I don't know that that renders it objectionable that he is doing it in an illustrative way, as opposed to just asking the hypothetical question. See what I'm saying?
I think it is. It's speculation as to what he did in some hypothetical situation. I don't think it would be relevant if he was describing what he did in some other case with Dr. Chambliss. What's relevant is what he did in this particular case.
Well, I'm going to overrule your objection.
thank you, Your Honor. So, Dr. Long, I'd ask you to listen carefully to this hypothetical, and it's going to be a rather detailed factual scenario. It's a hypothetical factual scenario. If it'll help you to take, would you like a notepad so you can take notes?
I'll just use the back of this, sir.
Well, if that's an exhibit, I'd rather you didn't use
No,
it.
this isn't the exhibit. This is my copy. I think you have the exhibit.
I'd rather you didn't even use
Oh,
that. So what I'll do is, I'll give you a little notepad here, and you can use that. How's that? We may have to mark this as an exhibit later on. That's one of the reasons I don't want you to use yours.
Oh, thank you.
Will that be big enough pad for you, Doctor?
I hope so.
Okay. So you're consulting with a pathologist, and he says, Dr. Long, here's the case. We have a witness describing a confession from the suspect. The suspect says he poisoned her with ethylene glycol, but she wasn't dying quickly enough, and he needed her dead more quickly, and so he panicked.
Well, I think that the objection is a sound one. The objection is sustained.
Okay, then I'll revise the hypothetical factual situation, doctor. The pathologist tells you, here's what we have. Allegedly, the victim was turned on her side.
Objection. Same grounds. This is an improper hypothetical for a toxicologist.
Well, that is going to ultimately be a problem that I suppose we're going to have to address at some point, is that this man is not a physician and is a toxicologist, which I understand to be a branch of toxicology or of pharmacology that deals with poisons.
Yes, there are two sides of the same coin.
What are
Pharmacology and toxicology.
Okay. How would you define toxicology?
Well, excuse me. Toxicology is the study of harmful effects of drugs and chemicals on living systems.
It's going to depend on the question that's asked, but you can frame your hypothetical, but I'll forewarn you that you will have to do so with surgical.
And I object to anything that's beyond the toxicology portion of it.
I'm going to count on you
scenario.
to voice an objection if and when it becomes appropriate.
We will.
Uh-huh.
Go
ahead, you're going to have to use surgical precision in forming your question.
Am I going to be able to get through the question before is there going to be some sort of commitment? I'll be able to get through this question now?
Well, I think if it takes a wrong turn, you can expect a spontaneous
There's
objection.
no commitment from me.
What'd you say?
There's no commitment from me.
I'm going to give this another go, doctor. So the hypothetical factual scenario is that the victim was found laying on her side. The pathologist describes to you injuries that are consistent with her being sat on with her face smothered.
Again, I object because this is medical testimony, not toxicology.
This is
No,
what
go ahead with your question.
so the victim is found lying.
Well, the decedent is found.
The decedent is found lying on her side. There is physical evidence, according to the pathologist, consistent with suffocation and a very low, an ethylene glycol level in her blood of 55 micrograms per milliliter. And the pathologist is offering the opinion that he just doesn't think she could have died from ethylene glycol poisoning. That was more likely suffocation. What would your response be to that?
And I object to the extent that it calls for him to give any opinion regarding the likelihood that the decedent in such a case would or would not be suffocated.
No, I don't think he's being asked that. He's being asked, I assume he's being asked whether or not death by toxicity could be ruled out sufficiently for the physician to rely on his voiced conclusion that suffocation was cause of death. But your question is objectionable because it is not expressed to the requisite degree of certitude.
Well, do you have an opinion to a reasonable degree of medical certainty as to what your
As to what? A reasonable degree of what?
reasonable degree of toxicological certainty
Probability,
as to
isn't it?
what your views would be on such a hypothetical factual scenario?
Yes.
And tell us what you believe you would be inclined to say. Reasonable degree of toxicological
Just one second,
certainty.
Doctor.
And I do object to the answer. Again, the appropriate question to ask would be, if someone asked you if someone could die from ethylene glycol with 55 micrograms of ethylene glycol in their blood, what would be your opinion? That's a toxicology. All this other stuff is prejudicial and beyond the scope of his knowledge or expertise.
The objection's overruled. You can answer the question.
Yes, sir. Thank you. Pathology trumps toxicology. As I said earlier, if somebody's run over by a train, that's a very different story than a poisoning. So it is the pathologist who's at the scene, who sees the body, who makes the determination based on their training and experience. The toxicology comes in as a mitigating factor. It can be the cause of death, or it can be a contributor to the cause of death. I can address the toxicology, but when I talk with the pathologist, I explain to them pathology trumps tox.
Now, Dr.
No, I just want to say one thing. What you heard from the district attorney was what's called a hypothetical question, which you've heard before. Keep in mind, as I told you before, that if any of the components of the question has not been proved to the degree of certitude required, that you should give no weight to the opinion.
Thank you, Your Honor. Now, Doctor, directing your attention again to your findings in this particular case. With this amount of ethylene glycol on board Julie Jensen, was there a sufficient quantity ingested by Julie Jensen to kill her?
Okay, that depends on the pathology. If you are demonstrating the crystal formation in the tissues, then yes. If you have no crystal formation, then you are looking at a low-level acute dose. So then you can't say it would be fatal. You need the pathology in the tissues, which shows that the ethylene glycol had been metabolized and that the toxic component, which is the oxalic acid, is present and is damaging the tissues.
Well, Doctor, if in fact you were made aware of the fact that there were slides of kidney tissue samples examined under microscope and oxalic acid crystals, numerous oxalic acid crystals were found in the kidney tubules, would that affect your opinion?
I object. It calls for speculation.
Well, this is something that you
Objection's overruled.
Yes, it would.
Well, in point of fact, you and Dr. Lavin had discussed this case, did you not?
Yes, sir.
And she related to you that she discovered the presence of oxalate acid crystals in the kidneys.
Objection, hearsay, confrontation, unless he's going to call Dr. Lavin, in which case I withdraw the objection.
I'll withdraw that question. I'll put a different question to the witness. Did you discuss this case with Dr. Mainland?
Yes, sir.
And Dr. Mainland has related to you that she discovered the presence of oxalate acid crystals in the kidney tubules.
Objection,
Is that correct?
hearsay.
She's going to be produced as a witness in this case, Your Honor, and it's not being offered for the truth of the matter asserted, but rather for the effect on the listener. In other words, whether it forms a basis for his expert opinion in this matter.
Well, then it
Would you
has to be-
typically rely upon opinions and statements made to you by others in your professional opinion?
By the pathologist? Yes, sir.
All right, you may answer the question.
Yes, it would.
And what did Dr. Mainland tell you about this case?
Do we have a foundation as to when?
That's for cross.
Okay.
When you find crystals in the tissues, then you know that the oxalic acid is producing the damage. You have the ethylene glycol present, you have the tissue damage.
Judge, this isn't answering the question.
Again, that's the questioner's objection unless it's irrelevant.
I believe there to be some limitation on when one question's asked and he states something else, because otherwise there's no control over the narrative.
I agree that there are cases in which some control has to be exercised, but that's not been shown in this case. Go ahead, doctor.
So when you have the ethylene glycol present and you have the oxalic acid in the tissues, okay, then you have toxicity, okay? And if that's the pathology, then that's the cause of death.
Now, doctor, could there be oxalate acid crystals in the kidneys actually, there are oxalate acid crystals in the kidneys of a person who dies from ethylene glycol poisoning that are formed before the person's actually dead from the ethylene glycol. Isn't that true?
Yes, sir.
So, would it be possible that this factual scenario, this level of ethylene glycol as described in your report, combined with the presence of oxalate acid crystals in Julie Jensen's kidneys, that they could be present right up to and at the time of death, and yet she could still have been asphyxiated? Or suffocated.
That is quite possible.
Now, tell me this. Assume for a moment, hypothetically, that that's the case, that at the point of suffocation, this amount of ethylene glycol was in the blood, the urine, the gastric contents, and that there were oxalic acid crystals present in the kidneys. At the point of asphyxiation or suffocation,
Objection to any assumption of fact not in evidence that there's any asphyxiation, suffocation.
Again, it's a hypothetical question, and the witness is being asked to assume facts which, if not proved, will destroy any evidentiary value of the opinion. Go ahead.
I'm going to ask the reporter to simply read back that portion of the question because I hadn't gotten to the end of it, and I want it restated exactly the way it was before the objection was stated, Your Honor.
Question, now tell me this, assume for a moment, hypothetically, if that's the case, that at the point of suffocation, this amount of ethylene glycol was in the blood, the urine, the gastric contents, excuse me, and that there were oxalate crystals present in the kidneys at the point of asphyxiation or suffocation.
Would the decedent at the point, and this is going to be a homicide victim, would the homicide victim at the point of asphyxiation be in a weakened state as a result of the ethylene glycol poisoning?
Yes, sir.
Tell us what kind of state you would expect the victim very likely to be in at the point of asphyxiation if this was the person's toxicological results and you are made aware of the fact that there are oxalate acid crystals formed in the kidney tubules.
The oxalate crystals show a prior use or exposure, and the presence in the gastric shows an acute dose. And what you'd be looking at is somebody who would be pretty sick, a very severe case of the flu, the nausea, the vomiting. They would just be feeling miserable. Your body goes acidotic, and all your chemistry shut down, your kidneys would be hurting you. You would just really feel very, very sick. You wouldn't have a lot of strength left.
Doctor, you described 3 stages of ethylene glycol poisoning.
Yes, sir.
Describe the third stage, what it looks like as it starts, what it looks like as it progresses, right to the point of death, and how long a period of time typically exists between the onset of the third stage of ethylene glycol poisoning and the end stage when the person dies.
Well, my rule of thumb is a person takes enough ethylene glycol to die, it's usually about 3 days. That would be my rule of thumb. I wouldn't go beyond 3 days. Is that possible? In as much as anything's possible. But I would say 3 days. So what you would be looking at is somebody who had passed the inebriation phase, who had gone into the formation of the oxalate crystals, and they would be starting to suffer the pathology. And this would mean that their heart would be damaged, okay, causing the tachycardia or the rapid heartbeat, that their kidneys would be damaged, so they could have a bloody urine, they would have difficulty urinating, and it would just progress from there. The lungs get damaged because this acid is in your body and it's chewing up your tissues. That's what it does. So the more that was present, the more oxalic acid that's formed, the quicker the decline into a fatality. If it's less that's present, well, then they can survive longer.
And while they're surviving in the third stage of ethylene glycol poisoning, would you expect them to be conscious or unconscious or lapsing in and out of consciousness, or would you know about that?
Well, I can't tell you how somebody would behave. Reasonably, they'd be, in and out, but that gets out of my area.
Doctor, going back to the chain of custody, when you receive these samples in the lab, are they typically sealed or unsealed?
They're sealed.
And if they weren't sealed, would there be a notation of the effect that they were not sealed?
Yes, that is where Diane transferred them to the refrigerator. It would be sealed and undamaged. We have a box in that now that's just checked for sealed and undamaged. But if there was a problem with them opening or leaking, it would be documented on the chain.
And there's no indication of any problem with the items that were received from the Kenosha County Coroner's Office or Medical Examiner's Office?
That's correct.
What's the exhibit number on the argument you have? Let's see. Here it is. The state would move S-119 into evidence, Your Honor, subject to cross-examination.
Is there objection?
That's the whole case file?
Yes.
Yeah, I object. It hasn't been discussed. I don't know what the basis would be for admitting it. It's all hearsay.
We'll take it up later.
Leave it up here. I have no further questions for this witness, Your Honor.
Mr. Alding?
Dr. Long, you're not a medical doctor, right?
I'm not a physician, no, sir.
You do not have a medical degree, true?
I do not have a physician's degree, that is true.
And what you do is you work in the lab, right? That's where
Yes,
your work
sir.
is done?
Yes, sir.
And you test samples from time to time, correct?
Yes, I don't do much testing anymore, but
And mostly you just supervise the other people who are doing the testing in your lab, is that fair to say?
yes, and interpret the results, yes, sir.
You don't treat patients, living patients?
No, sir, other than my children.
You don't treat people who have been poisoned, right?
No, sir, I do not.
When you describe stage 2 or stage 3 or stage 1, you're describing what you've read, right?
Pretty much, yes, sir.
you haven't seen people who have suffered from ethylene glycol poisoning who are living, right?
I don't treat patients, sir.
Have you seen any living patient who is suffering from ethylene glycol poisoning?
No, sir.
And you also spend a lot of your professional time testifying in court, right?
Unfortunately, yes, sir.
And that's why you know to turn to the jury and explain your answers, right?
No, actually, I do that because I teach.
That's something you've learned over the years as a witness, to talk to the jury that way?
No, I teach. So I talk to whoever the audience is, I talk to them.
And you've testified, what, thousands of times?
I don't think it's that many, but I know it's been a bunch.
Certainly hundreds.
I would say over 30 years, yes, sir.
Yes?
Yes.
As you indicated, you didn't do the testing in this case?
That is correct.
You didn't observe the testing being done?
If I did, I don't recall that.
Your first contact, well, how is it that you were first contacted in this case? When was the first you heard about this matter?
Specifically, I don't recall. I know we received the samples from the Kenosha coroner's office requesting ethylene glycol. So that would be, I guess, the first contact on it.
Did you talk to the medical examiner?
I may have spoken with him at that point, yes, sir.
Do you recall speaking to the medical examiner at that time?
I believe there was a conversation about it, yes, sir. And so that's why we were going to do a retest. I believe there was.
Who was that conversation with?
I believe it was Dr. Lavin.
Did you take any notes of that conversation?
No, sir.
Did you talk to Mr. Jamboys at that time?
No, sir.
And how do you know that?
We were just setting up to do the testing. Mr. Jamboys wasn't involved with anything at that time. He didn't get involved till much later.
How do you know that?
Now, that's from some of the material I got when he sent it to me.
Did you read the police report where it indicated Mr. Jamboys was at the scene of Julie Jensen's death?
I don't recall seeing that, sir.
Okay, but that if he were at the scene of the death, then he would have been involved from the very first day, true?
Yeah, and then he would have, yes, sir.
You were told by Dr. Lavin that she suspected this was a homicide?
I don't recall that, sir. I know she suspected ethylene glycol poisoning. Just take a look here and see. No, there's no mention of homicide.
Well, you didn't take any notes, right?
Well, from the notes we have here, when on the test request, it just says that crystals were found, and the body was found by the husband and tested for ethylene glycol.
Well, you're not saying that this one-page report tells you everything you learned from the medical examiner, right?
No, the test request is what we learned from the medical examiner.
As I understood it, Dr. Long, you had a conversation with Dr. Lavin, true?
Yeah, I believe I did, yes, sir.
And the question is whether she told you her suspicions that this was a homicide at that time.
I don't believe so, no, sir, but it was 10 years ago.
What instructions were you given about this case in May of 1999?
It would have been to test for ethylene glycol, which is what's on the test request.
Were you asked then to write a report?
Well, we generate a report from our toxicology test results. That's automatic. That would have been sent back to the Kenosha coroner.
That is a report that just has the toxicology results, correct?
Yes, sir.
And you can also write a report in a case that gives your opinions interpreting those toxicology results, right?
Yes, sir.
And you ultimately did that in this case, right?
I believe that was in 2003. I think it was 03.
And I'm asking you if you ultimately did that in this case. We'll get to the timing later. Did
Yes,
you do
sir.
that? And were you asked in 1999, were you told that you would be, that the Kenosha County Medical Examiner's Office would want you to write a report?
At that time, no, sir.
When is it you first spoke with Mr. Jambois?
I don't know, sir. I don't have messages. I didn't take phone messages and record them.
But you didn't take any notes, did you?
Oh, the phone messages? No, sir.
Well, you didn't just have phone messages. Over the years, you've had a number of conversations with Mr. Jambois, right?
I've had conversations with him, yes, sir.
How many conversations, Dr. Long?
I don't know, sir.
More than 20?
That seems kind of high. I would say it's less than 20, but
You don't keep any track at all of any of those conversations, right?
no, sir. I handle 50 to 80 phone calls a day, sir. And so I don't keep track of all the phone conversations. I just don't get to do it.
Because you handle so many telephone conversations per day and you're handling so many cases, it's really pretty much impossible to remember what's going on with each of those cases. True?
Well, up to a point. I may not remember all the details, but I'll say the same thing on day 1 as on day 100.
Well, do you have a single note from any conversation you've ever had with Mr. Jambois?
No, sir.
Do you have a single note from any conversation you've ever had with Dr. Lavin?
No, sir.
Do you have a single note from any conversation you've ever had with Dr. Mainland, who's the current Kenosha County Medical Examiner?
No, sir.
And you are aware from working in criminal cases over the years that if you had notes, those would be required to be produced to the defense, right?
We would produce the entire case file, yes, sir.
And that's why you don't take notes. True?
No, sir. That's not true.
Well, do you try to take notes?
I try to take notes, yes.
But you just didn't succeed in this case in keeping a single note.
Well, when you're working in the laboratory and you have blood samples and you're in gloves and you take one off to get the phone, you don't get time, and you handle a lot of phone calls, you don't get time to make all the notes and to see that it gets into the case file. I haven't been able to, sir.
Well, you have pen, I presume you have pens in that laboratory, right?
Yes, sir.
The paper, right?
Yes, sir.
You're able to write with a glove on, right?
Yes, sir. Well, you shouldn't write with a glove on because you contaminate the pen.
You take the glove off, Dr. Long.
Yes, sir.
You got a big supply of gloves in your laboratory.
Yes, sir.
And basically, you really don't do much testing, as you already indicated, right?
Now, sir, you're talking 10 years ago.
You've been working on this case for 10 years, right?
Well, it's been hanging fire for about 10 years, yes, sir.
Right, and you've had conversations with Dr. Jambois and, Dr. Jambois, here we go again. Mr. Jambois. Mr. Jambois in 99, 2000, 2001, 2002, 2003, 2004, 2005, 2006, and 2007, and now 2008, right?
Objection, Your Honor. I object to these questions about whether he's discussed this case with Mr. Jambois or not. I'm not a witness in this case. I don't see how it's relevant.
If you say so, sir, I know I've spoken with him. I don't know how many times, and I don't know when.
Well, when was the first time you spoke with him?
I have no record of that, sir.
What information did he give you the first time you spoke with him?
A bunch of material was sent to me about it, and it was summarized in the material that I've given to you last summer.
Okay. Well, in 1999, you first received material in this case, right?
That would have been the test requesting. I'm assuming you mean other than the actual samples and testing.
I do.
I guess it was around then, sir. I'm really not positive.
And if you had notes, that might help refresh your recollection when you're testifying in an important case like a homicide case, right?
Sir,
Objection, Your Honor. It's argumentative and it's irrelevant hypothetical because he doesn't have notes and he's repeatedly indicated that.
Sir, I wish I had notes, just to give them to you.
In 1999, the prosecutor sent you information, right?
I believe it was in 99, sir.
And what you received, sir, was a foot-high stack of materials, right?
Well, I estimate now that it was a foot high. Whether it was 8 inches or 12 inches, I'm not positive.
Okay.
But it was a lot of material.
Right, and whatever size that material was, whether it was 8 inches or 12 inches or 16 inches, you lost every inch of it, right?
Well, we've been through this, and I told you I had help. They filed it, and we couldn't find it, and they're no longer with us.
And would you agree with the definition of lost is no longer able to find it?
Okay, yes, sir. I lost it.
And it's been lost for about 8 or 9 years now, right?
I think it's probably around, yeah, I think that's about right.
All right. And you don't recall what was in those files, right?
From my memory, what was sent to me more recently just summarized it. I had the original hard copy material because it was so voluminous, but what was sent to me was a summary of it.
And it was sent to you in 1999 with the intention of having you write a report, correct?
I didn't do a report then. I don't believe I was asked to do a report then.
What was the purpose in sending you the materials?
I guess information about the case.
And what were you going to do with that information about the case?
I don't know. If they called me up to talk to me about it, I would have the information.
Do you remember any instructions you received along with the material?
No, sir.
Was it your understanding you were supposed to do nothing with the material?
Well, read it, and that was about it.
And nobody ever followed up with you about that material?
Not that I'm aware of, sir.
Mr. Jamboy sent you new material in 2001, correct?
Yes, sir.
Do you recall any of your conversations with him then?
No, sir.
In fact, it's your position that you can't recall a single conversation with any prosecutor in this case prior to August 2007, right?
I don't have any specific recollections of any conversations with any prosecutor at all, sir.
Did you ever talk to a police officer in this case?
I don't believe so. I may have, but I don't believe so.
Can you remember any specific conversation you ever had with any medical examiner prior to August 2007?
Well, the only one, as I said earlier, I believe I spoke with Dr. Lavin about us doing the retesting, but I'm not positive about that. I believe it, but I'm not positive, sir.
So is it your testimony you can't remember any specific conversation you ever had with a medical examiner in this case?
That's correct, sir.
So you can't remember any conversations with prosecutors, police officers, medical examiners about this matter?
That's correct.
Dr. Chambliss never called you about this case, true?
No, he did not.
At some point, well, in 2001, you received those materials in about February, is that right?
I believe so, yes, sir.
Were you asked to do a report then?
I believe a report was requested the following year or two later, not at that time.
And ultimately, you did a report on March 11th, 2002, is that right?
Yes, sir.
And you were aware that the complaint then was issued just a few days, a week or two after that?
No, I wasn't, sir.
No one told you that they were issuing charges based on the information you provided?
No, sir.
Did you talk to Dr. Lavin around that time?
I may have, sir.
Well, do you recall Dr. Lavin having to testify at a preliminary hearing in this case?
I vaguely remember something along those lines now that you mentioned it.
Did she ask you, you understood that Dr. Lavin was an inexperienced medical examiner?
Well, I wouldn't comment on her experience, sir.
Well, you knew she had been in the job just a very short time in Kenosha County, right?
She was new to the position, yes, sir.
You were aware that this was her first homicide?
No, sir.
Were you aware this was the first case of ethylene glycol poisoning?
No, sir.
Do you recall her consulting with you in an effort to make sure her preliminary hearing testimony was accurate?
She probably did, sir.
And she discussed with you how much ethylene glycol would have been in the stomach of Julie Jensen, right?
She probably did, yes, sir.
And you also had conversations in 2002 and 2003 with Mr. Jamboys, right?
Reasonably, yes, sir.
And he also wanted to try to understand the toxicological evidence in this case, right?
Yes, sir.
And he asked you questions about what the stomach contents were, right?
Yes, sir.
He asked you questions about how much ethylene glycol was in the stomach, right?
I guess so, yes, sir.
And he wanted to understand, he didn't understand what 3,940 micrograms per milliliter meant, right? You expressed
Objection,
that.
Your Honor, as to this witness testifying as to what I did or didn't understand.
Sustained.
So you explained to him the significance of the numbers in your view. True?
Objection is hearsay. What this witness said to me years ago was
It doesn't
hearsay.
strike me as being offered to prove the truth of the matter, so objections.
Well, I object on relevance.
Well, overruled.
Could you repeat that question?
Can I have that read back, please?
Question, you explained to him the significance of the numbers in your view. True?
Probably, yes, sir.
Dr. Long, I'm going to show you what's been marked as State's Exhibit 7.
What is that?
It's the, I'll ask him in a moment here. That's it. No, you'll,
What is it?
just, you'll note, it's the autopsy report. Dr. Long, is that the autopsy report from Dr. Chambliss?
Yes, sir.
And you've seen that before, right?
Yes, sir.
That's part of the new file?
Yes,
right?
sir.
Was that part of the file that you lost?
Probably.
And can you tell me where in Dr. Chambliss's autopsy protocol it indicates that he obtained gastric samples for testing?
Objection, Your Honor, it's irrelevant. Why would this witness be testifying about somebody else's report?
That's the kind of report you rely on typically in your practice, right?
Well, how is it
Well,
relevant?
we've got a couple of questions pending. Why don't you answer the latter one first? Is this a type of report that you would typically rely upon in your
Yes, sir.
practice, in your profession?
Yes, sir.
All right, and the other question then was, does the report indicate that the gastric contents were withdrawn from the stomach?
Were taken, what was my question? Were obtained for testing.
Well, I think, time for a break, I think. Let's not talk about the case and the usual.